All right, can we still seize evidence under plain view if the suspect hides it before we seize it? All right, so let's see if this makes sense. All right, so guys, my name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing a roadside chat from Addison, Texas. We're at the fire station doing training for the PD. So train the whole entire department here. And I just want to give a shout out to Addison, one of my favorite departments, and I mean that. Just a great cops. We have just a lot of great relationships here with officers and so forth. So this officer is from Missouri. They asked this question, all right, so I have my little iPad here. The scenario is this: an officer is lawfully present in a house, let's say consent. While lawfully present inside the house, they see something readily apparent as contraband. I like the way this officer's talking, using language from case law. Gun box, if the person is a known felon. Baggies of drugs, etc. in plain view. But for whatever reason, the guy sees what's going on and he moves it into a drawer, into under the mattress, under the couch. I don't know, right? And now it's no longer in view, into a backpack. Excuse me, no longer in view. Now that there is no longer plain view, does the officer have to apply for a search warrant based on the probable cause? Or is there a court exception to just grab it, right? To open up that drawer, under the mattress, whatever, backpack, and just grab it. Okay, we're also not talking about a situation that there is exigency. There is no imminent destruction of evidence, right? We could also seize this guy and take him out. There is actually an exception, right? There is an exception. This exception is generally under the framework of foregone conclusion doctrine, okay? The foregone conclusion doctrine. That doctrine is still kind of in its infancy about, the Supreme Court mentioned something about a foregone conclusion in a case in like the 1970s involving tax records. But the idea here that the courts are saying is, hey, look, is there really any meaningful privacy interest that we're trying to protect here under these facts, right? The cop saw the evidence. The guy now hides it. He hides it. What are we protecting now? What are we really giving this guy by forcing us to go to the courthouse to come back with paper? In other words, if we would have seized it, if we were quick enough, we'd be okay. But we hesitated a few seconds and the guy ended up hiding it, now we're not okay. That's not really what most courts how they're gonna look at this. So for my prosecutors out there, if they have a situation like this, look under foregone conclusion doctrine. I also do have a case that supports this, and give me a little bit of time and I'll drop that into the comments, or not the comments, but the description, that talks about this idea that once cops see something, there's no incentive of getting a warrant if the person now it's in a closed container. All right, there's your answer. Hope it helps. And if I have helped you get it right every time, making good case law, if you like what we're doing here at Blue to Gold, you can help us by sharing these videos around and helping us get more subscribers. All right, that's all I ask. Until next time, my friends, see you later.